Hi there, you are watching a previously recorded video. If you have any questions that are very specific to your brand or require assistance with legally protecting your brand, please feel free to reach out to us at www.jnjlegalservices.com. Schedule a discovery call with us to get you on the right path to success. Do you know the special language that's included within the name Fashion Nova? I'm gonna give you 5 seconds to guess what language is within Fashion Nova. Did you guess? It's Latin. Yes, Fashion Nova has a Latin word inside of its name. I actually studied Latin all 4 years of high school as a requirement, but I love Latin so much that I went on and majored in it in college as well. I double majored in psychology and in Latin. So I'm a little bit of a Latin nerd, but yes, Nova is actually a Latin word, and technically V's in Latin are pronounced as W's, so we're pronouncing Fashion Nova wrong. It should actually be Fashion Noah, which means new fashion. But that little tidbit brings us to the topic of today's video. If this is your first time seeing my face, I am Jaleesa, your friendly neighborhood lawyer. And for all my returning subscribers, welcome back, my alien allies. It's nice to have you here. Welcome to another episode of our Alien in the Courtroom series, a series aimed at helping young entrepreneurs and business professionals at making better legal decisions for their brands. And today's episode is all about trademark law, and particularly trademarking foreign words. Yes, you can trademark foreign words, but there are a couple things that you need to consider if you are thinking of doing so. So if you'd like to learn more about this, then just stay tuned. As always, it is important that I stress that these videos are intended for educational purposes only. In no way should you consider me to be your personal lawyer. And if you have specific questions about your brand, you should definitely seek outside counsel. A little shameless plug. Today, I am actually wearing my clothing line. This shirt here, my Legally Black shirt, I think it has a double meaning if you are in the legal profession, is available as a t-shirt like I am wearing now in multiple colors, and available as a sweatshirt as well in pink, black, fun colors too. We should not be penalized for the color of our skin, and it seems that in the United States it's illegal to be black. So this shirt is just standing out as a protest to say that my black skin is still legal. If you like this shirt, I have a lot more things that you may like in the legal profession for Black Greeks. For anyone that's different and weird and eccentric, you're bound to find something that you like at my store. So go ahead and check out www.alienintheroom.com. Back to the video. I previously talked about trademark law, what is a trademark, how it works, what it protects, how long it lasts in episode 1 of this series, where I gave you an introduction to trademark, copyright, and patent law, as well as episode 2, where I talked about building a strong business name in the eyes of the law. So if you need to learn any further information about trademark law, be sure to check out those first 2 videos for an introduction. But I'm going to go ahead and insert a clip from those videos that will give you a little bit of a refresher of what trademark law is. Trademark law refers to a word, phrase, symbol, product shape, or logo by a manufacturer or merchant to identify its goods and distinguish those goods from those made or sold by another. So in trademark law, words, phrases, symbols, slogans, product shapes, logos, all of that is usually referred to as marks. So if I use the word marks in this video, just know that I'm talking about trademarks. It is a mark that helps customers know that that product is a part of your brand. But one thing I didn't say in the first episode that I'm letting you know now is that there is no such thing as trademark rights in a word. So what a trademark really is the use of the word in connection to a particular good or service. Rise and shine, Kylie Jenner. I can't just trademark the words rise and shine. I have to trademark the words rise and shine in relation to clothing, like what she's trying to do now. So when you apply for a trademark, you have to say what the words or phrase or logo is and what's the products that are being sold. A trademark equals word plus the product/service being sold. Trademarks are also usually defined into categories called classes, and practically anything you can think of, it fits into a class. I believe that there's 45 classes total. Class 14, for example, is jewelry products. Class 25 is all clothing, including footwear and headwear. And influencers, for example, may want to trademark their name under advertising services, promoting brands, goods and services of others, and endorsement services. And because trademark is defined by classes, that's the reason why brands can have the same name. So you think of Dove soap. Dove soap is not owned by the same people who do Dove chocolate. Two different brands, two different products, but the same name. You understand what a trademark is now. Yes, you can trademark a foreign word. Again, it just needs to be in connection to a particular good or service. When you successfully trademark a foreign word or phrase, it will prevent any competitors from using that particular word or phrase to promote or sell similar products or services. It will not prevent people from using the word conversationally because, again, trademarks only apply to the word plus the field. For example, the French phrase "c'est la vie" is a registered trademark in a line of cigar products. However, you still have to be careful. When trademarking foreign words, the USPTO uses a guideline to determine whether that name, that word, that phrase should be considered trademark worthy. Not an absolute rule, but that guideline is called the Doctrine of Foreign Equivalence. It is available on the USPTO's website. There is a trademark manual of examining procedure. It was last updated on October 2018, and I will be reading directly from that manual regarding the foreign words. So the Doctrine of Foreign Equivalence is a guideline that requires courts and the committee that would determine your trademark to translate foreign words in determining whether they are registrable as trademarks or confusingly similar with existing marks. The doctrine is intended to protect consumers in the United States from confusion or deception, as all trademarks are meant to do. The Doctrine of Foreign Equivalence applies in two ways. First, foreign words that translate to generic or merely descriptive English words may not receive trademark protection where a consumer in the United States would recognize the generic or descriptive meaning of the word. We talked about spectrum of marks where you can have a strong password strength versus a weak password strength, and technically that will still apply to whatever foreign word you have translated. The further you get to being generic, the more necessary it is for other companies to use that word, meaning that you cannot trademark that word. So for example, you can't trademark the word shoes in relation to your footwear line because other companies need to have access to the word shoes. You are not the only shoe company out there. The higher or the closer that you get to fanciful and arbitrary is the less necessary for producers or companies to use that word, which is a good thing. So if your foreign word, I don't even know what, zapatos. If your foreign word zapatos translates to shoes and you are selling shoes, it is considered generic and you will not be allowed to trademark that word. For example, a trademark applicant will not receive legal protection for the word trademark pomme frite if the trademark applicant uses that trademark to promote the sale of French fries. I don't know if they have a new location now. I believe so. The store, the restaurant that's in New York City, it sells French fries with like different sauces to go with it, and they cannot trademark pomme frite because it means French fries and they are selling French fries. This also makes me think of the Kim Kardashian kimono fiasco. I think back in 2018 or 2019, Kim decided that she was going to come out with that shapewear line and she wanted to call it kimono, and now it's called Skims because she had a public outcry to not use the name kimono for her underwear line. But kimono in Japanese actually just means clothing, and clothing describes the product that she's selling. It actually turns out that she was attempting to trademark kimono body, kimono intimates, and kimono world, because again, kimono would just translate to clothing and that's what she's selling. So you can't trademark a word that translates into what you're selling. Kimono world, clothing world. That's a smart way around it. Attaching just that one word can really change it in the examiner's eyes. The second way that the doctrine of foreign equivalent works is when Foreign words are confusingly similar to ordinary US customers who speak the foreign language and have familiarity with the words. If one applicant uses the word French fries to sell dog toys, and another applicant attempts to use the French words pomme frite, I believe it's French, to also sell dog toys, the two cannot exist because they are confusingly similar. But there is an upside, because the doctrine should only apply when it is likely that the ordinary American purchaser would stop and translate the foreign word into its English equivalent. And the ordinary American purchaser is someone who is knowledgeable in the foreign language. So you want to think about it in terms of those languages that are popular in the United States. A person, an ordinary customer, is more likely to have the knowledge to translate it. So when you're trying to use a foreign word as your trademark, you want to think of languages that aren't so common in the United States. For example, Spanish and French, you are probably going to find Spanish and French users in the United States. But maybe if you have a language that isn't as common as Spanish and French, you may have an easier time using that as a trademark. Maybe any of the African languages may not be as common in the United States. Even though they exist, they're probably not as common that people can stop and translate. But the best way to protect yourself from people who can stop and translate is to probably use a dead language. Think about using Latin, or think about using languages that are so obscure that not too many American purchasers may know it, and you would probably have a better chance of getting a trademark. While foreign words are generally translated into English for purposes of determining descriptiveness, foreign words from dead or obscure languages may be so unfamiliar to the American buying public that they should not be translated into English for descriptiveness purposes. The determination of whether a language is dead must be made on a case-by-case basis based upon the meaning that the term would have to the relevant purchasing public. Fashion Nova is smart in the sense that they use Latin, a Latin word, a dead language. There's not that many people in the United States that can say that they know and speak Latin, especially speak Latin, because the way that you learn Latin isn't that you actually say it out loud, is that you translate it and write it down onto paper. So if you ask me to speak Latin to you, I'm not going to be able to speak a sentence to you. I can translate anything that's going on. And if I hear like a vampire TV shows love to use Latin. So most of the time, if I hear them speaking it, I can hear the words that they're using and I can translate that, but it's not something that I can readily speak out loud. Latin is generally considered a dead language. However, if evidence exists that the relevant purchasing public still uses a Latin term, or if the term appears in current dictionaries or news articles, then that Latin term is not considered dead. The same analysis should be applied to other uncommon languages. Okay, that's a great thing to note. A term like nova, it isn't a term that is used in ordinary English language. So Fashion Nova possibly has a trademark on their term. The USPTO isn't going to translate Nova. But if you have a Latin word that exists within the English language or exists within the English dictionary, then that word is not dead. That means that the examiners will translate the word and then determine whether that word matches too closely to the product or service being offered. So for example, the word abacus is actually a Latin word that has been adopted into the English language, and you're going to have a hard time trying to trademark a name that has abacus in it if you are selling a type of calculator or counting device. Or even Latin descriptive words like magnum or major, which mean great. Fashion magnum or fashion major is less likely to get trademarked compared to Fashion Nova, because magnum and major are already words within the English language. So that brings us to the end of this video. If you are considering trademarking a foreign word, again, consider using a dead language or a very obscure language. Or if you're using that word, make sure that word has nothing to do with the products and goods that you are offering, because it might likely be translated, and if it translates to something that you're describing the goods, you're in trouble. I hope you learned learned from it, and I hope you enjoyed this video. Give me a thumbs up if you did. Leave a comment down below of any questions you have from this video or any future questions that you would like me to address in the next video. I would love to know what you are struggling with. Share this video with an entrepreneur. That person can possibly benefit from my series. I'm sharing a bunch of information that should be very valuable to said entrepreneur. So be sure to share it with a friend. Subscribe if you haven't already. Shop my clothing line if you haven't already, okay? I have things for you guys there. I have legal things, I have Black Greek things, I have pro-Black things, and I just have weird, eccentric items as well for all my eclectic, fabulous ladies and men out there. I will talk to you guys in the next video. Bye.